Hello, this is Erick Widman. I'm an immigration lawyer, and in this video, I'm going to lay out for you an overview of how to get an employment-based green card, and that is called EB1, Employment-Based First Preference Category. So that's what we're going to focus on first, the EB1A, B, and C. So starting from the top, EB1A is for individuals with extraordinary ability. We all hope we could be within this category. Our parents probably think we're extraordinary, but USCIS could think otherwise. So if you're someone with an extraordinary ability in the fields of the sciences, arts, education, business, or athletics, you may qualify for permanent residency, a green card, by self-petitioning, actually. So you don't have to actually have an employer in this particular subcategory, as long as you continue in the same field of the work that you've been pursuing before. The law defines someone to have extraordinary ability when you're a person within a small percentage who's risen to the very top of your field of endeavor. You'll need to show through extensive documentation that you sustained national or international acclaim and that your achievements have been clearly recognized in your field through evidence of huge, important national, international awards, your own scholarly publications, media articles about you, your leadership role, your recognition by your peers, commanding a high salary, serving as a judge of others, potentially, and letters of endorsement, amongst other things. You don't need to show all these items, but you have to show multiple categories. Although a job offer in the US is not a requirement, you still need to demonstrate that your work in the US will substantially benefit the country. It's very helpful if you already have specific work-related projects planned. And in order to apply, you need to submit Form I-140, just as if an employer was doing that. But a labor certification, thankfully, is not required. The second main category, the EB1B, is for those who are outstanding professors and researchers. So if you have at least 3 years of experience teaching or research in your academic area and you received an offer to pursue tenure or a tenure track teaching position or a comparable research position at an institution of higher learning, you may apply for permanent residence under EB1B. So you can't self-petition in this category. You must also show that you're recognized internationally as outstanding in your academic field, and this requires extensive documentation demonstrating major awards, prizes, original research contribution, authorship of scholarly books or articles. And by the way, no one has all these things, but you have to have a minimum number. A citation of your work by others, serving as a judge of others, or membership in these distinguished organizations. So again, you can't self-petition for an EB1B, but your employer must submit Form I-140, and a labor certification, thankfully, is not required. The final category for the EB1 group of individuals who are getting an employment-based green card is the multinational managers and executives category, EB1C. So if you're a manager or executive of a multinational company who has been employed for at least one of 3 years in the past by an overseas affiliate, parent, subsidiary, or branch of a U.S. employer, you may qualify for permanent residency under EB1C. If your employment at the related foreign company was in a managerial or executive capacity, that's good, that's key. And your job offer has to be in the same category within the US. Your employer does not necessarily have to be a large company with multiple international offices, but the US employer must have been actively engaged in doing business for at least 1 year. So if you're coming to the US to open a new office, you wouldn't qualify for the EB1C. However, you could apply for an L1a visa. The criteria are pretty interchangeable. And that L1a is a non-immigrant visa for intra-company transferees. EB1C is a good option for executives and managers already in the US under the L1a category because the criteria is so similar. If you're already employed in the US by a related US entity with an L1a visa, you can show that you obtained 1 year of qualifying foreign experience within the 3 years before coming to the US. In order to apply for this EB1C, your US employer must file Form I-140, must extend a job offer to you, and a labor certification is not required. So that is one of the major benefits of the EB1 category. It's very difficult. Few people are able to show that they meet the stringent criteria for this, but you can avoid the difficult labor certification process. Thanks for watching.